You couldn't breathe, but you were breathing in it. You couldn't swim, but you were swimming in it. It washed you clean the day that you were born. Fed your food with it so you could grow strong. We need clean, clean water. We need clean water. It's colorless by design. Life's blood for all mankind. Your first fish from it, waves crash down. Your first drink with it, on the rocks, royal crown. We all live by it, 'cause it feels like home. Find your solitude on it, especially alone. We need clean water. We need clean water. It's colorless by design. Life's blood for all mankind. Yeah, the tide is rising. What we're gonna do? The fish can't filter it, and the wildlife too. Said the tide is rising. What we gonna do? And we become the cage in the regulator's zoo. Life's blood for all mankind.
Hello, everyone. I'm Ken Crystal, Professor of Law and Director of the Environmental and Natural Resources Law Clinic at the Whiting University Delaware Law School in Wilmington. I was supposed to do this talk live in person back in March, but in the COVID craziness of 2020, I'm going to have to do it by video. But that's okay, because we have lots of things to talk about, and video is certainly a good way to present those to you. Before we begin, I do want to give a shout out of thanks to two important drivers behind this workshop and the work that it represents. First is the Inland Bays Foundation. They generously supported the clinic's work in creating what we're going to talk about today, which is the Citizen's Guide for Effective Environmental Advocacy in Delaware. The Austin Moyer Chin Citizen Advocacy Program of the Foundation was essential to the work of the clinic and our continuing work to provide you with information and guidance on how to be an effective environmental advocate. Also want to give a shout out to the Socially Responsible Agriculture Project, or SRAP, whose tireless representation of citizens and advocacy on behalf of the environment continues to shape how environmental law is viewed and practiced in the state of Delaware. So today, I want to provide you with an overview of the Citizen's Guide, what it says and how you can use it, and some of the highlights of the issues that hopefully the guide will help you deal with as you try to advocate for the environment in the state of Delaware. What I'm going to cover in this video is really sort of three different parts. In part one of the video, we're going to talk about the process of environmental regulation in Delaware at the state level. In the second part, we're going to talk about some strategies for effective public participation before regulatory decisions are being made. And then in part three, we're going to talk about strategies for effective public participation after regulatory decisions are made. So let's go to that part one. And let's talk about the process of environmental regulation in Delaware at the state level. In order to talk about this, we have to think about, where does Delaware environmental law come from? And there's really three different sources. The first are statutes passed by the Delaware General Assembly and signed into law by the governor. Most of the environmental statutes are found in Title VII of the Delaware Code. And you can actually access the code itself if you go to this URL. And at that URL, you can actually find the various statutes that are being referenced. And here's a little guide that might help you in dealing with the code. Citations to the code that you'll often find in DNREC documents, public notices, applications, etc., generally follow the following format. They start with the title of the code that it's referring to. So in this case, it would be 7. Then there's a shorthand reference to Delaware Code. Usually that's capital D, E-L period, capital C period, so Del Code. And then a section number, section 6004. And a little clue can be found in the fact that the first two numbers in the section number, the first two digits, that actually tells you what chapter within the title this particular section can be found. So 7 Del Code section 6004 can be found in chapter 60 of Title VII. So that's one way to help navigate around the code. But the statutes at the state level are one source of environmental law. A second source are the regulations that have been passed in order to implement the various statutory provisions. And there's a lot of regulations. You have to be able to find the right section, and you can do that on the DNREC website by looking under the Administrative Law tab, and you'll find regulations. And the regulations tend to be grouped by the DNREC division that issued them, and we'll talk about those divisions in just a minute. But the regulations tend to provide a lot of detail, whereas the statutes tend to be a little bit more general. So those two things, statutes and regulations, provide the bulk of Delaware environmental law. And then the third source are court cases that you can find that interpret the statutes, interpret the regulations, And there aren't as many of those, but they are out there, and there's something that have to be taken into account when trying to interpret what particular regulations or statutes mean. So we have statutes, we have regulations, we have court decisions. What that whole structure points towards is that there is one primary environmental regulator in the state of Delaware, and that's the Delaware Department of Natural Resources and Environmental Control, or DNREC. And you can see how the letters in DNREC come from the first letters in the title of the agency itself. So DNREC's the primary regulator, and that's whose actions we're primarily going to be focused about when we talk about environmental regulation in the state of Delaware. So what is DNREC? Well, it's an agency created by the General Assembly, and it is headed up by the Secretary of DNREC. And then there are several divisions within DNREC that carry out different aspects of DNREC's environmental regulation and control duties. You can see the list here, and they're very, very different from each other. And frankly, they're somewhat isolated from each other. So sometimes when an issue might implicate multiple areas, one division making a regulatory decision might, but sometimes might not, reach out to somebody else in the agency that has the particular expertise to answer a question. It's an issue that sometimes you have to be careful about. But what this long list of divisions tells you is that DNREC has an incredibly broad range of responsibilities, from parks, from fishing licenses and hunting licenses, etc., to the regulation of hazardous wastes, to clean water type issues, to air quality, to the coastal zone, to climate, all kinds of issues. And so it's a large agency, and as I said, sometimes the divisions are a little bit insular from each other. So you need to understand that when you're confronting what DNREC is up to. Now, what are the areas, if we can kind of classify them, the areas of law that DNREC administers? Well, there's various state programs, and as the different list of divisions suggests, they're pretty wide-ranging. But any state program that empowers DNREC to do something, DNREC has to carry out the necessary regulation as specified by the state statute. But DNREC also administers some aspects of federal programs. The Federal Clean Water Act includes a permitting program called NPDES, or it stands for National Pollution Discharge Elimination System. That's what the NPDES stands for. But it's a system of permitting sources of pollution of water under the Federal Clean Water Act. And that federal power has been delegated to the state of Delaware, and DNREC administers that program. Same thing with the Clean Air Act. In connection with permitting under the Federal Clean Air Act, DNREC carries out that permitting program instead of the US EPA. So these are, again, different areas of law that DNREC is administering. And as the different divisions suggest, it's a very wide-ranging portfolio of responsibilities. But there are a couple of things that DNREC does not regulate, even though you might think that it does. One issue is about zoning. DNREC does not have the power to zone. That power is given instead to the counties. And some counties then give their power or share their power with municipalities. Zoning is about approval of whether or not land can be used in a certain way. So, if I want to build a factory, I need to have land which is zoned in a way that allows for factories to be on that land. If I have property that's zoned residential, I probably can't build a factory, so I need to do something about the zoning. But because zoning is about how the land is used, and zoning is not something that DNREC does, decisions about whether or not a facility can be built really lie at the county level, at the zoning level, and not at the DNREC level. DNREC does not have the power to say, well, we don't think it's a good idea that a factory be built there. That's for the county. And if the county says it's okay to do that, DNREC doesn't have the power to override that. The other area of law that DNREC does not regulate, I listed as NEPA. And what does that stand for? Well, it actually stands for a federal statute called the National Environmental Policy Act. It's one of the first modern environmental statutes that was passed in the United States. This is the federal statute which says before a federal agency acts, you need to consider the environmental impacts. This is the statute that requires, in some circumstances, the creation of environmental impact statements and things of that nature. DNREC does not implement or carry out that federal NEPA statute, nor is there any state statute which says that DNREC has to do an environmental impact analysis before a project is allowed to go forward. So it's important because sometimes we think of DNREC as being able to stop the building of a factory in a zoning kind of way, or to require that all the environmental impacts be studied before the project can go forward. And DNREC just doesn't have that legal ability to do that. So that's important to remember, because what it means is that if in fact there is zoning approval, then what DNREC is worried about is, all right, well, if you're going to build your factory, will you comply with the state requirements for such a factory to operate? And so DNREC's focus is on compliance with the statutes or the regulations, not on the wisdom of whether or not this particular thing should go forward. And so it's important to remember that, because that limits DNREC's ability to stop a project. You might have to fight that fight at the zoning level, not at the DNREC level. Now, when we talk about public participation in this decision-making process, this regulatory process of DNREC, perhaps the best way to think about it is that DNREC works itself up to, it does all the work, analysis, and ultimately the secretary of DNREC makes a decision. And that is really the key to any environmental regulation at the state level. The secretary's decision is an important inflection point. And so when we talk about public participation, we are talking about participating either before the secretary's decision is made or after the decision is made. When we talk about pre-decision or before the decision, the kinds of things we're really talking about are sometimes DNREC will hold workshops where information about a project is presented. That may, although often does not, create opportunities for the public to provide some input into the process. By and large, the biggest opportunity before the Secretary's decision for public participation is the ability to comment on a proposed permit. And we see that happening when there is public notice. And the public notice will do one of two things. It will either say that we're just noticing up the fact that we intend to issue a permit and create an opportunity to submit comment, usually in writing, but there's no public hearing. Or the public notice says we are going to have a public hearing, in which case then there's an opportunity to submit both written and oral comment in the process. So pre-decisionally, public participation is about providing information, providing comments to DNREC with the hope that it will ultimately impact and perhaps change the Secretary's decision. Once the Secretary makes a decision, however, you can't influence the decision anymore. Instead, all you can do is challenge whether or not the Secretary followed the law in making the decision. And so the post-decision opportunities for public participation are really about appeals of the decision by the Secretary. And so that's what we're talking about in terms of the public participation opportunities. Now for the second part. We've decided that there is, in fact, opportunities before a regulatory decision is made by the Secretary for the public to participate, to provide comment and input. And so in this second part, let's talk about strategies for engaging in that kind of public participation. There are really two important things that you need to think about. And it's an important strategic decision that you need to make. Do you want to simply express your opinion about the project? It's a good idea, it's a bad idea. Or do you want to do something that would affect DNREC's decision about the project? And while you might think that, well, if I express my opinion, doesn't that affect DNREC's decision? The fact of the matter is these are two separate things. And let me tell you why. DNREC's approach to issuing a permit is to say the decision has already been made at a zoning type level for this to go forward. Right? And so DNREC's job is to see, is the proposal something which complies with the relevant state laws? They're simply trying to figure out whether or not what the applicant proposes to do would meet the requirements that state law says it has to meet. Your opinion, while it may be very important to you, is less important to DNREC. And that's just a reflection of the fact that they feel like the decision is made someplace else. And their job is to simply say, does the law require certain things, and have they been included? Will that be done? Yes. Right? And so your opinion, or even your questions about what DNREC is doing, will tend not to cause DNREC to change its mind about anything. On the other hand, if you can tell DNREC that those decisionally important facts, say, a requirement under the law to do a certain act, prepare a certain analysis, treat the water a certain way. If you can tell DNREC, you know what, they aren't meeting that legal requirement, that does affect DNREC's decision. Because DNREC ultimately has to say, yes, it does. And so if you're saying, no, here's why it does not, that can cause DNREC to say, oh, you're right. We need to require something different. Or maybe in an extreme case, we have to say, no, you can't do it at all because you can't meet this requirement. So this initial strategic decision that I'm pointing out here is to simply say, if you want to affect DNREC's decision, you need to do a little bit of homework. You need to do something more than to simply say, I'm against it. Now, that doesn't mean you can't say, I'm against it, or I think this is a really bad idea, right? You're still entitled to raise that opinion. My point is simply that it probably won't change DNREC's decision. But if you do the work and you find reasons why DNREC should decide against the permit that it wants, or to change the permit so that it is more protective of the environment, those are the kinds of things that are going to get DNREC's attention. And so that's how we want to think about effective public participation going forward. All right, well, how do we do that? Well, the primary way you do it is through comments. And so what you need to be able to do is to understand that your goal is to produce a comment that will provide DNREC with information that will potentially alter its decision. Okay, how do we do that? Well, the first thing we need to do is we need to know what's coming and when. DNREC's website provides public notice of proposed permitting actions. Here's what DNREC's website looks like. And if you go to the Administrative Law tab, you can see there's a pull-down menu. There's the regulations that we talked about before, but there are also public notices. And you can click on there to see what public notices are currently being made. And those public notices can often tell you about new permit applications that might be about a project, and also tell you important information, including and especially two things. One, when our comments due, because that sets a deadline. And two, whether or not you need to make a request for a public hearing. And we'll talk about that in a little bit. If a matter goes to public hearing, that's also listed on the website. And if you look down the left-hand side, you can see that there is a place where you can look at public hearings, the ones that are noticed up, protocols for how to submit public comments, and to register to make a comment at a public hearing. So there's lots of information that can be made available to you that you can then look up. So here, for example, are currently pending public hearings that are planned. And you can click on one of these, and they may, in fact, provide information such as applications, etc., that will be relevant for what we're going to talk about in a minute. So the DNREC website is an important place to find out what's coming and when. These public notices are also, by the way, published in the newspaper. You ever see those public notices at the back side of the paper, and there's a million of them, and they're in small print, and you never want to read them. But you can actually find the ones in the main newspapers in the state where DNREC publicly notices up things. So that could be another place that you can find out this information. But the key thing is you need to know that a permit application has been submitted, and to the extent that there's going to be a public hearing, you want to find that information. Once you've got that information, once you've found that source, you want to make sure you understand your deadlines and any requirements that you have. And in the Citizens Guide, there's actually a checklist. It's checklist 3.1 that's designed to sort of prompt you to get the information you need so that you understand what's due when. And so the checklist can be a helpful way for you to know what's coming and when it's due. Once you've got that preliminary information, now you want to think about becoming knowledgeable about the project itself. Checklist 3.2 in the Citizens Guide gives you some helpful prompts to find out information about the project. Often on the DNREC website, you can find application materials where whatever this process or perhaps facility is seeking a permit for, they describe what they do and how the process works. They provide information that is designed to meet the regulatory requirements that DNREC is going to be checking the project against. So the application materials can often be a treasure trove of information. I will also tell you that they can be very dense, very technical. And so sometimes you might read them and your eyes will glaze over. I know it happens to me. But if you want to find out about the project so that you can look for ways in which DNREC can be required to make sure that the process works in an environmentally protective way, finding out the information about the process through the application materials or through your own research, Googling things, etc., might lead you to some information that could be helpful. Now, here's a warning. There is some skepticism about whether or not something found on Google is necessarily true, right? So you want to be careful about the information that you want to present to DNREC, because if DNREC just says, well, this is not an appropriate scientific study, this is somebody just made this up, we're not going to pay attention to it, it's not going to help you. But you can find things like studies that were done elsewhere that might provide information that DNREC should know about in making its decision. So become knowledgeable about the project, not just what it does, but also what the impacts are or what they could be, because that's going to help you then be able to formulate comments to say, DNREC, you need to pay special attention to X or to Y. And here's why. The third thing you want to think about is whether or not you want to request a public hearing. Now, first, why would you do that? Well, a public hearing is helpful in a couple of different ways. Number one, a public hearing will require DNREC for sure, and oftentimes the applicant, to show up in a public forum and explain what's going on. So a public hearing can, in and of itself, provide you with additional information that might be helpful for you formulating a set of written comments. Now, in many instances, public hearings are not scheduled. DNREC does have the ability, if it believes that there is sufficient public interest that a public hearing is a good idea, they can just say, we're going to have a public hearing. But it is much more often the case that DNREC says, we're not going to have a public hearing unless somebody asks for one. And so one of the things you have to think about is, do I want to ask for a public hearing? Because it might get me that additional information. And also just the process takes a little bit more time than not having a public hearing. It has to be publicly noticed up 20 days in advance. Then they actually have to have the hearing. And so it can slow things down a little bit. And that can be helpful if you're trying to gather all your information together to be able to submit comments. So requesting a public hearing can be a very good strategy in many instances. The Citizens Guide, it has a checklist. It's checklist 3.3 about requesting a public hearing, and that can guide you in terms of preparing one. The key thing is, right, is that there is a general standard found in section 6004 of Title VII of the Delaware Code. And it says a public hearing request will be granted by DNREC if it's meritorious. And this is the standard that's used. A request shall be deemed meritorious if it exhibits a familiarity with the application and a reasoned statement of the permit's probable impacts. So what does that mean? Well, first, you can't just say, well, I want a public hearing because I want a public hearing, right? You've got to show that you are familiar with what the project is trying to do. And you have to be able to say, here's what I think are the impacts, and I think we ought to have a hearing about it. This is where the homework that we've been talking about, that becoming knowledgeable about a project, is helpful. The checklist gives you some language that you could use if you want to. But the key thing is that you have to be able to show that you know what this project is about and that you believe there are certain impacts that are going to happen from this project that you want explored at the public hearing. So requesting a public hearing can be an effective way of also getting public participation, right? But the ultimate goal of doing your homework, becoming knowledgeable, requesting a public hearing is to provide public comment. And so let's talk a little bit about what that means. There are two kinds of public comment. There's oral comments and there's written comments. Oral comments, as the name suggests, is you simply speaking, saying your comments. Now, the thing about oral comments is that they're only allowed if there is a public hearing. If there's no public hearing, you cannot do oral comments. And while you can just stand up and say what's on your mind, right, oral comments tend to be very limited in time. 3 minutes, 5 minutes, depending on how many people want to present. Rarely goes above 5. And so when you think about humans talk at maybe 130, 140 words a minute, 3 minutes is not a lot of words. You can't say a lot in that period of time. It's not to say that oral comments are not a good idea. They are. They can be. But you have to recognize that they have limitations. By contrast, written comments can be submitted whether or not there's a public hearing, and they can be as long, as detailed as you want. There's no time limits. There's no page limits, right? And so written comments tend to be a good way to provide a lot of information to DNREC to affect the decision-making process. It's also possible to combine them together, right? You can submit written comments to make all your points in detail and use your oral comment time to simply hit the high points. Sometimes oral comments can be helpful if some brand new fact comes out because of DNREC or the applicant's presentation at the public hearing. So think about using them together, but the more effective form of public comment is going to be written public comment. And so that's why you want to, if you want to really affect the decisions, you want to think about making written comments. All right? Okay, how do we do that? Well, we really should have two goals. One is to provide some legal or factual basis for DNREC to decide your way. And by this, what I mean is, if the regulations or the statute require that something be done, and your analysis of the application indicates that's not being done, well, providing a written comment which says, hey, they haven't met this requirement of the regulations or the statute, so you shouldn't issue the permit because they've got to meet that requirement. That's providing a legal basis for DNREC to do what you want to do. Or it could be a factual basis, right? It could be that, well, the regulation says to do X, and what they're doing isn't really going to be very effective, right? So they're just kind of paying lip service to what X really needs or wants. Here are the facts which show that, if you don't contain the wastes in a certain way, that causes pollutants to get into the groundwater or to seep into the local river or whatever it might be, right? That can be a factual basis. But again, your goal should be, let's provide those legal and factual bases to DNREC to say, hey, don't grant this permit until these issues are resolved. The second goal of written comments is to create a record for appeal. We're going to talk about appeals in part 3 of this talk. But the point here is that appeals need to have information that was before the secretary at the time the secretary made the decision. They're limited to the record before the secretary. So by providing factual information, by providing legal points, by providing these things to DNREC during the written comment period, you're putting that before the secretary. And so you can then have that as part of the record that you can rely on if you decide to appeal. Checklist 3.4 in the Citizens Guide kind of helps guide you through doing that. But if you follow those two goals, you can create a set of written public comments that can be very, very focused and very challenging for DNREC to ignore. The Citizens Guide also includes some copies of public comments that I've submitted on different matters, and you can see the level of legal and factual detail that they can get into. There is no reason to scrimp in your written comments, and so you want to be as complete and thorough as you possibly can be. And Checklist 3.4 can help get you there. Now, as I said before, oral comments have limitations, but they can still be helpful. Checklist 3.5 in the Citizens Guide can help you prepare good oral comments. You just have to remember that your time is limited, so it really has to be hitting your points and emphasizing them as best you can at sort of a summary level, so that then the hearing officer can understand the point that you're making and have it affect DNREC. So, written and oral comments are the goal, are the way in which the public participates prior to the regulatory decision being made. The more effective those comments are, the better your chances are of affecting DNREC's decision-making process. The third and final part of our talk today is about strategies for public participation after the secretary makes a decision. Many times, despite the best efforts to submit public comments, DNREC goes and approves a project in a way that you think is not appropriate or correct. So what can you do about it? How can you participate after the secretary's decision has been made? Yes, we're going to grant the permit. And that's what this part is about. After the decision is made, your advocacy is really about appealing the decision. Right? In effect, you want to go someplace and say the secretary got it wrong. Wrong on the law, or wrong on the facts, or maybe both. And the statutes identify how and where you go do that. Right? Now, there are really three key issues that affect appealing a decision by the secretary. First, what's the forum that you need to file your appeal in? Because there's actually two different forums that you can focus on. Second, what are the time restraints? Right? You have to file your appeal in a certain amount of time. And third is an issue called standing, whether or not you have the right to bring an appeal. So let's talk a little bit about each of those. First, the correct forum. Most decisions by the secretary, once they're final, and the secretary issues what's called a secretary's order, are appealed to the Environmental Appeals Board. There's one exception to that rule. And that is when the secretary issues a decision under the Coastal Zone Act, then you don't go to the Environmental Appeals Board. You instead go to the Coastal Zone Industrial Control Board. So the Coastal Zone Industrial Control Board deals with appeals of decisions made under the Coastal Zone Act, but only the Coastal Zone Act. Environmental Appeals Board deals with issues for decisions on anything other than the Coastal Zone Act. So you got to pick the right forum. Second, there are time limits that govern the appeal. If you're appealing to the Environmental Appeals Board, you must file your appeal within 20 days of the secretary's decision. Now, that 20 days has a little bit of flexibility in it because the 20 days can run either from the actual issuance of the decision itself or when it is publicly noticed by publication in newspapers. And sometimes that publication requirement gives a few extra days. But by and large, from my own perspective, I always operate on the most conservative view possible. So I want to file an appeal within 20 days of the actual date of the secretary's order. If I can. Sometimes I can't. But 20 days. With the Coastal Zone Industrial Control Board, you only have 14 days. And part of that is because, unique to the Coastal Zone Act, there is a very tight time frame in which an appeal must be filed, a hearing must be conducted, and a decision must be made by the board. That all has to happen within 60 days. So there's a sense built into the statute that this has to move quickly. And the 14-day requirement to file an appeal is part of that. So you have to understand the timing. The third issue, what's called standing, is about whether or not the person who files the appeal is someone who is affected by the decision that's being made. I don't want to get into all the legal stuff, but the key thing is that there is sort of a three-part test that courts and the boards will apply to determine whether or not someone has standing. First, can the person who's filing the appeal say that they have suffered or will suffer what's called an injury in fact, that some interest will be injured? A common one in environmental cases would be recreational interests. I will recreate less, or my recreation will be less enjoyable because the secretary's decision allows this pollution to happen or allows something to happen that makes me less want to recreate. All right, so an injury in fact, you have to be able to show that that injury is caused by the decision you're appealing, and you have to show that if the board rules in your favor, you can, in some way, shape, or form, redress that injury, reduce it. So those are the three elements of standing. So not everyone has standing to bring an appeal. As a matter of fact, there's case law in Delaware which says anybody can submit a public comment, but only those who are injured and can meet those three parts of standing, only those people can bring appeals of decisions. All right. So I can tell you from experience, standing is an issue that is always at the top of everyone's mind when it comes to an appeal, either to the Environmental Appeals Board or the Coastal Zone Industrial Control Board. And so part of what you have to be able to do is show that you can meet the standing requirements in order for your appeal to go forward. Now, assuming that you can establish standing, right, then there's the process itself. And let me just describe briefly how the process works. Whether you're before the Environmental Appeals Board or the Coastal Zone Industrial Control Board, there's a process by which this works. In both, the party who's bringing the appeal, who is in effect saying the secretary made some kind of an error, has what's called the burden of proof. They have to show that the secretary, in fact, erred. And there's a presumption in the law that secretaries don't err. So you really have to have a case that would convince the board that, in fact, the secretary did err. And that burden is always on you as the appellant. Now, generally, what's involved is you have to prepare your case. And obviously, that's amassing the information that you want to present to the board, right? But there's also requirements where there's a pre-hearing conference with counsel for the board and the other parties. Usually DNREC is represented. And more often than not, the applicant will also show up. So you have to sort of formulate a strategy for how the hearing is going to go forward. You have to present the case itself at the hearing. And you have to be ready to respond to what DNREC or the applicant's going to say in their attempts to say, you haven't met your burden of proof. All right? So that's the process. And what's important to remember is that the process is triggered by the actual filing of an appeal, right? So there are steps related to what you have to say and do in order to file an appeal. You got to do that. And then you've got to prepare your case and be ready to present it to the board. It operates kind of like a court hearing, even though it is not always following court rules. So it's not an easy thing to do as a person who's not a lawyer, but it can be done, right? But we represent a lot of clients in the clinic who want to challenge decisions, and so we're familiar with this process and how it works. The key thing is that at the end of the process, the board must make a decision. And a lot of times what they'll do is they'll confer amongst each other and then they'll announce a decision. But that's not the final decision of the board. Delaware law requires both of these boards to formalize the decision in a written order. And it's the written order that ultimately acts as the decision of the board. And so that's how the process ends. A written order is issued. And once that written order is issued, you then have the ability to appeal that order. You can appeal those decisions to the Superior Court. You generally have to do it within 30 days of the issuance of the written decision. It's based solely on the record before the board. And the arguments to the Superior Court are really going to be made through legal briefs that explain why the board erred. And DNREC and the applicant are going to get their chance to say why the board got it right. And so you have these legal briefs that go back and forth. And then ultimately the Superior Court makes a decision. The Superior Court's decision, which comes out in a written order, can then be appealed to the Delaware Supreme Court. Again, it's a similar process. You got to file that appeal within 30 days. It's solely based on the record that was before the Superior Court. And again, you're arguing primarily through legal briefs about why the Superior Court erred. And so that's the process. Public participation then, after the regulatory decision is made, is about filing and participating in an appeal. Because it is such a legal process, it's helpful to have the assistance of a lawyer. And that's one of the reasons why the clinic exists, right? We don't take every case, but we represent people who want to challenge decisions by DNREC, and this explains how the process works. I hope you found this overview of the Citizen's Guide to be helpful. By all means, read the Citizen's Guide. There's lots of information in it that can be helpful. And if you have questions or comments, feel free to email me at my law school email address if you want to know some particulars. We as citizens are the check that exists on DNREC's exercise of its regulatory authority. Sometimes DNREC gets it right, and sometimes DNREC gets it wrong. And it's effective public citizen advocates who can help improve DNREC's performance by holding DNREC accountable through these processes that are outlined in the Citizen's Guide. I want to thank you for watching. Again, thanks to the Inland Base Foundation and SRAP for all that they do. And I hope that you found this to be informative and helpful.